We're going to go into now a little bit of an overview of LB 561. As Judge Gindler introduced me, I'm Corey Steele. I'm Deputy Administrator. I've been placed in charge of the Juvenile Services Division with Probation Administration, which was created based on the passage of LB 561 and last year LB 985 that we'll talk about a little bit as well, and some pilot success that we've had across the state in a few jurisdictions. Yesterday was a wonderful day up in South Sioux City as we presented during that time. We went long, which gives some people a little bit of heartburn as they're trying to move the day along, but it was great because of the questions. The questions that were asked during that presentation really helped flow the presentation a lot better than me standing up here and talking. So at any point in time, please ask questions as we go through. We'll break down a little bit of the system of what we view in probation as the new juvenile justice system for Nebraska. Just so you know, Judge Johnson, I think there was, who else was here? Judge Johnson is here and maybe another judge or two. I may defer questions to you. There are a lot of judicial questions that come about and there are a lot of legal questions that come about. Even though I've immersed myself in statute, even though that I can read statute and decipher statute, I am not an attorney, so I try to stay away from answering legal questions. I can talk about process, I can talk about things, how we see the system moving forward, big picture, those types of things, but I may defer to Judge Johnson or some of the other judges in the room to answer some. Judge Gindler's been very gracious over the past few presentations to answer some of those questions that have come about. I bring up Judge Johnson because Judge Johnson is a chair of a transition team. Chief Justice Heavican with LB 561 passing and moving forward, we knew that, I think everybody in here who has read that bill, there's a lot of holes or what we call cliffs in the bill where maybe some statutory language changes, but there's some missing statutory language or missing pieces of what to do next. And so there's a committee, Judge Johnson from here in Omaha, Judge Heidemann from Lincoln, Judge Payne from McCook, and Judge Rowland from Sidney Kimball are on that transition team. And myself and Carol McMahon-Boyce from Judicial Branch Education are there as resources, and we bring in others as need be. Linda Leatherman is also on there so that as we're discussing and moving that her system, the justice system, can move as well with all of these changes. So I may call upon some of you to ask if there's some expertise questions that come about. Where'd Judge Teskey leave the clicker? There it is. Once again, LB 561 is what we say is a collaborative effort between the Supreme Court Chief Justice's leadership, Department of Health and Human Services, and the courts and probation in moving forward in what can we do different in the system. 5 years ago, Ellen Burkowski, our administrator, and the leadership at that time of DHHS sat in a room and said, how can we do some things differently? We have too many kids that are state wards. We're spending too much money on services delivery. We are seeing our motion to revoke rate increase in probation and more kids becoming state wards. Why is that? And we really brought it down to the simplest level saying, we are sending kids that are on probation that are violating because they have issues or needs, and we're not able to address those issues or needs, so we make them a state ward in order to get the funding and the services that they need. And so as we sat in that room and had this discussion, it really came upon us. One of the individuals in the room said, this is fundamentally wrong, that we have to make a juvenile a state ward, put them in state care and custody in order to get their service needs met. That's at its simplest form how we started crafting the Juvenile Justice Project that has led into LB 561, the portions of LB 561. We know Senator Ashford and his creation of 561 started off with this big monstrosity of this new Juvenile Justice Division, and as we worked over the past year with this bill, really crafted it to what is LB 561. With that said, as I talked about the cliffs and the holes in the bill, there will be a lot of cleanup that comes forward. Meetings this past week with Senator Ashford, Senator Koash, Senator Christ have all said, we want to make this a better bill, so we need input in how to make this a better bill with those holes and gaps. And also Senator Purchase here as well. So those things are going to be addressed this legislative session. So I'll move forward. I'm going to talk about the pieces of the system and where we've come from. So there's a little bit of background. Here are what we say are the system impacts in LB 561. Juvenile intake. Pre-adjudication supervision and services, which is new in some jurisdictions, which is new for law violations, and is new for some jurisdictions for probation to provide pre-adjudication services and supervision. So I'll touch base on that as well. Detention alternatives and cost. We'll talk about, as Judge Teske had shown, JDAI. We are a JDAI site. We have Juvenile Detention Alternatives Initiative in Douglas County and in Sarpy County. We are forming a statewide collaborative. Janice Walker, the court administrator, and Senator Bob Christ are the co-chairs of our statewide collaborative, and we're moving forward with a statewide implementation. And the Atlantic City reference that Judge Teske talked about is exactly that. They're bringing 4 to 5 states in to move JDAI statewide and move it to state scale. And Georgia in Atlantic City they're in the exact same position we are in forming a new statewide collaborative and moving that initiative forward. So we'll be going and spending some time in Atlantic City to continue to move that forward. Evaluations. Evaluations have dramatically changed from going away from the Office of Juvenile Services evaluation or the CCAA to single-focused, court-ordered specific evaluations and a 21-day time frame. We'll talk about those. Case management and services. Judge Teske really touched base on this, is where we've been transforming our system over the past few years with identifying risk, targeting the right issues, getting the right services put in place. So we'll talk about case management and service delivery with probation. And then reentry, brand new to probation, is what does reentry look like? As Chief Justice talked about earlier in his speech, reentry is not only from YRTC, Kearney, or Geneva, but we're broadening that, reentry from any out-of-home placement. Those elements of reentry still have to take place anytime a juvenile is in out-of-home. And what's it take to get them back into home and the supportive services as well. So we'll touch base on reentry both from YRTC Kearney and from out-of-home placement. And then another big piece of the bill, I'm not going to touch on every aspect of the bill, but another big piece of this bill is the impact of community aid dollars. And those community aid dollars through the Nebraska Crime Commission. So at the end I'll touch base on that with the creation of a couple new positions and some enhancement of community aid dollars. So at any time I'm going to touch base on all of these. During that discussion, please ask questions. Pictures are good. Ellen, our administrator, loves pictures because it really helps define what we are trying to accomplish here. This is our picture of what we see the juvenile justice system transforming to with LB 561. It's really creating a pillar or a strong system is what we're trying to present here. We have 4 pillars within this system, as I talked about. Intake and detention alternatives. That's going to be a focus of probation, and we're going to have specific guidelines in that, what that means, and detention alternatives statewide. I'll touch base on that a little bit more. This first pillar is that entry into the system. We have a risk screening assessment that we do at juvenile intake, which is in line with Casey. We've worked with Andy Casey and the JDI initiative over the past several years to make sure we've crafted that new detention risk screening assessment in a proper manner, working with them. Building detention alternatives statewide. Do we have detention alternatives statewide? I see people, Roger Harris from Gage County, do you have detention alternatives? In Gage County, you have home or you have detention, right? Or staff secure in Sarpy. We'll build some of those in-between services within your community so we're not having to place a kid in the deep end, high-end detention because we don't have any other options. So building those detention alternatives. Least intrusive is our mantra. We do not want to just place a kid in a higher level care because we don't have anything. We want to create those services. Pre-adjudication investigation is that second pillar. This is also adding new components to what probation has already done. We've provided predispositional reports to the courts for years and years and years. Now we're enhancing this because there's a couple things that go under pre-adjudication supervision. Now it's not just an investigation, it can be single-focused evaluations ordered through the judiciary in a 21-day time frame, more assessments, greater flexibility with behavioral health assessments, also creating predisposition or pre-adjudication supervision and service delivery for voluntary cases. And I'll go into a little bit more detail. That's a new piece of the system as well. Figuring out financially as we move forward through the system what parts and pieces are going to pay for the service delivery with that juvenile. There also is that, like I said, the 21-day evaluation that can be done, or excuse me, evaluations, not a 21-day, that's after adjudication, but pre-adjudication evaluations that the court can order through probation as well. So I'll touch on those. Case management. Once again, case management is the core of what probation is about and what we've been about. We're going to enhance our case management, continue to go down that road of figuring out those criminogenic, or what Judge Teskey talked about, those issues, those 8 core issues. We utilize the YLS. Everybody, if you're working in the juvenile side, that's our risk screening assessment that determines what areas we need to address, what services need to get put into place to address those high-risk areas. We want to target those high-risk areas, target those higher-risk juveniles, focus our attention on high risk versus low risk, as Judge Teskey had talked about. The higher risk, more intensive case management, more intensive service delivery in order to keep the risk reduction down. And the utilization and expansion of graduated sanctions. About 4 years ago, LB 800 passed, which was the big truancy bill and all of those things. Also within that was juvenile graduated sanctions, which allows flexibility with probation for technical violations to put different service options in place for those juveniles. So our ultimate goal there is risk reduction. And then new to probation is the reentry, or the former OJS parole. One of the major pieces of LB 561, and the beauty of 561, is that judicial oversight from the front end to the back end. No longer does a judge lose jurisdiction when the juvenile goes to Office of Juvenile Services or Department of Health and Human Services. When the juvenile goes to YRTC, the court still has jurisdiction as well. So that is a placement at YRTC through the court, and they come back with court approval through the reentry process. Once again, high engagement even at the facilities, where there's family team meetings once a month, transition plan. So during a 60-day notification that comes from the Department of Health and Human Services that this juvenile is ready to transition, we will engage and create that individual reentry plan. The court will have oversight of that reentry plan, and that entry plan will be implemented prior to that juvenile being back into the community. Our goal is no kid gets released from YRTC without those services being set within the community. Once again, the hearings, when that juvenile is released, there'll be those hearings, and high intensity supervision. Very low caseloads, high intensity. These are our highest risk kids that are going to go to that highest end care. We want to make sure that that transition is appropriate. Reentry on out of home is the same. We will identify when that juvenile is ready to transition. We will create that transition plan back into the community, build those supports around that family, so there's in-home services in there, and so we have a very successful transition. All this is done with the partnering with education, making sure appropriate placements. One of the positions that we've hired with LB 561 in the administrative office is a director of placement. We're stating in the probation administration, we do not want any kid placed in any facility that we have not gone to, we have not seen, and we have a knowledge base of what's going on, from facility makeup to the services that they're providing while that juvenile's in there. As Judge Teskey talked about, if we just place kids in facilities because it's a group home, they're registered, and we send a kid, but we've never been there ourselves, we're doing a disservice. So we got to hold those facilities responsible too, and up the bar in how we put kids in that congregate care or that out-of-home care. So successful transition and that appropriate placement. Culture and gender-specific service delivery, building that service delivery. We're a little bit different in probation. We don't do these contracts. We do fee-for-service. This is, if you're a provider in the room, hopefully you've gone through our training, fee-for-service. We figure out what that juvenile needs, and then we figure out the funding. We don't let the funding drive where we're going to place a kid. I had a judge yesterday, we were in South Sioux City, and one of the judges up there says, Corey, it's routine that if the kid needs a service and the only place to get that service is literally right across the Missouri River, we can't get it. We are told no, DHHS won't pay for that service because it's not a Nebraska-based provider. And I promised that judge, and I've told that judge, our goal is to increase services within Nebraska. That's our ultimate goal. We've challenged providers to say, here's the service we need you to provide it. But if you can't, and we're in Omaha, and it's right across the river, or we're in South Sioux City, and it's right across the river, or we're in Sidney, Nebraska, and it's right into Wyoming, that's the service that kid needs. That's what we'll do to get that service. We're going to continue to work with our providers to build those services, but the ultimate goal is to get that service need for that kid no matter what it is. And we figure out the funding on the backside. We don't let the funding drive what the kid's going to need. Youth-informed and enhanced family engagement. This is a crucial piece in building our system. I've been open and honest in all of these meetings the last 2 weeks that this maybe is where we haven't been as skilled in probation and been up to snuff and where we need to be. We have not had the youth be at the table. We have not let the youth lead the discussion. Youth informed, what do you need? What can we do to help? I'm here as a probation officer to help you. What can we do together? Same with the family. We've never had the family team meeting atmosphere. We've never had the family is driving this case plan. And that's where we're going with the probation department now, is that enhanced family engagement, the training that's going on, the increased accountability with the youth and the family is going to be there as we meet with all the providers in service delivery. So this is our picture. Any questions on our picture as I move forward? I'm going to drill down on each 4 of these pillars as I go through. Yes, Judge?
Corey, on the reentry piece there, if we have a young man at Kearney or a young lady down at Geneva, and we don't get that 60-day reentry notice within their first 6 months in the institution, we'll conduct a regular 6-month out-of-home review, won't we, on that?
Great question, and this question was asked yesterday, and I posed it. We actually had a noon meeting yesterday, which was fabulous with that transition team. Actually, I'll refer to Judge Johnson, let him take that question because we talked about it yesterday. It's really a judicial question.
Part of it is reasonable efforts drawn down and emergency findings, are we getting there? And so we think that we ought to. And you know, if it's still contrary to come home, why is that the case? What reasonable efforts are being offered to do that? When do we think our target date for reunification or other permanent objectives will be achieved? Just like in the 3A cases.
So with that discussion yesterday, and I've also had a lot of discussion the last couple of days with Judge Gindler on this, is solidifying that. So how can we do this? We're working with the 2 facilities to try and do some video conferencing, and I know you utilize that in your jurisdiction now, but how can we do that so we're not running these kids all over the state for a hearing as well? How can we conduct that within Kearney and the Geneva facility in order to make that on the record, in order to make that hearing a little more convenient for not only the court but the juvenile as well and the family, so the family can still be a part of that. Great question, Judge. I'll talk a little bit about, and at the end I'll come back in and talk a little bit about the success of the pilot project that we had here in Douglas County and in Judicial District 11 and 12. But first I want to talk about where we see the benefits to the system with LB 561. One of these things is reducing financial barriers. One of the beauties of our project is we're not solely paying for every service for that juvenile. We're working with that juvenile and that family to determine what service needs need to be met. We pool funding. Some of the services that we fund, it may be 3 or 4 funding sources that pay for that service. So our goal is not to use all of the dollars strictly to pay for everything. It's stretching and maximizing our resources in order to pay for that. So an example of reducing those financial barriers. If a family has insurance, they may have insurance that can pay for that intensive outpatient, but maybe they have a $1,000 deductible, and we go through their inventory financials and we see they can't afford a $1,000 deductible. We then would tap their insurance for the primary cost of the intensive outpatient, and then we would backfill with our project dollars. Or we've had Medicaid, where Medicaid may pay for this service but not this service, so we'll maximize Medicaid, and then we would pay for some of those services as well. So pooling those funding, reducing financial barriers to accessing those resources. Whatever it takes to get that service, we'll get that service need met. Focus on single focus court-ordered evaluations as well. CCAA, OJS evaluation ranged from $1,800 to $2,500 depending where you are. 5-part eval, very costly, very intrusive to the juvenile. Sometimes we were doing them every 6 months just to get Medicaid coverage. We're really looking at single focus specific evaluations. If the juvenile has a substance abuse issue, then that's the evaluation that we need. If there's mental health issues, that's what will get put in place for that juvenile. We have screening instruments as well. A question came up yesterday from one of the judges says, maybe I'm not sure what evaluation to order. Work with your local probation department, say I need you to do some upfront screening so we can identify this is the route of evaluation that's needed versus just guessing from the bench. Because the judge made a great point. They come in first appearance or maybe even at adjudication, and maybe it's not a substance abuse issue or a mental health violation, but there's some of that fringe that the parents are talking about. How do I know specifically what to get? And we have some upfront screening instruments that we can do that can help flag and determine specifically what evaluations are needed and work with the judiciary on that. The family partnership as well. In the bill, you'll see a lot that talks about family team meetings, family engagement, those types of things. That family partnership is going to be crucial in order to make this work. And once again, that overall judicial support. We talk about the judicial support and why we feel that the judicial support from the front end to the back end is going to help with building the right system. I'm going to move on and talk about this first pillar in a little more detail. Intake and detention alternatives. What does this mean and how are we going to do this? Okay. Once again, we are a JDAI state site. We are moving forward in that fashion. Our risk assessment is one that we've created with the help of Andy E. Casey Foundation. It's not a new per se tool, but we revamped that tool in 2013. July, trained all of our probation staff. Our goal is we're only placing 2 types of kids in secure or staff secure detention. That is, they're a risk to the community to commit a violent act, or they're a flight risk. Are we doing that today? No. We know, based on that tool, that we still are putting close to 40% of those juveniles in secure or staff secure detention because we have no alternatives to detention. So they're screening, they're not a risk. They're screening, they're not a flight risk, but yet we're still overriding placing into that detention facility. So we have to create and build with community support and other support those alternatives within those communities. That could be as simple as adding electronic monitoring to the menu in Gage County. It could be having a provider expand shelter care services to include other jurisdictions. There's some creative ways and some things that we're going to put into place in order to have more options at that intake time. One of the new things in LB 561 is payment for detention. We're currently working with all the detention facilities on arranging what this looks like. It outlines that probation will be a payee for some of those juveniles that are in the facilities. We want to work with the facilities to say, our goal obviously is to reduce the number of kids in detention. We think and feel we can very successfully reduce close to 40% of those kids in secure detention and staff secure detention. What does that mean for those facilities? We really want to work with those facilities to expand services as well and increase. Maybe that facility, we're working with one facility in western Nebraska that's saying, I want to do more. My population is down. Can I be a provider for the electronic monitoring? Can I run a reporting center? Can I do tracker services out of my detention facility? And the answer is, quite frankly, yes, you can do all of those, and that's what we want to help build and grow within those facilities. It's changing the philosophy of what that facility does, and it's not just a strictly detention facility. Okay? Any questions on intake? Yes, Judge.
It strikes me that this is not going to be successful unless we can somehow do away with the risk-adverse pervasive attitude that's always been in Nebraska among probation officers, caseworkers, everyone. They don't want to be the one that says, I'm going to risk sending this kid home. They'd rather just detain him, bring him to me, and have me order him released.
Right.
It defeats the whole thing if we don't do it right at the point of attack.
Yes, you're exactly right. That's why we're highly engaging our probation staff who's making those decisions, because one of the things we're working with them on is, because that's always the question that gets posed back to us when we're doing the training. Who's held liable if something happens with this kid? That's always a question that our probation staff asks. And I said, you're held just as liable at an intake decision as you are during case management, as you are with your recommendations to the court at predispositional investigation. You're held liable for all of that. That's your job, to make the most appropriate and best decision. And we will back you, because it's not going to be 100% of the cases, as Judge Teskey talked about, are going to go well. But we will back you based on our screening assessment that says this kid is high risk or low risk, what to do. You have some, it's not the gut saying I think, it's there. If you go through that form and you go through the steps, you've made the right decision. And so it's a training issue, and you're exactly right, Judge, and that's where we have to continually mentor our staff to make those appropriate decisions. But I'll tell you, by adding alternatives, they feel safer. By saying, you know, I can keep that kid at home if I put an ankle bracelet on that kid. Now, that's less damaging to that kid, right? They're not going into a facility. They're not having that dramatic effect of going into a locked facility, but it also allows a little more safety net for that juvenile. And those will still come in front of the judge within that time frame because we've altered that placement. They'll come in for that detention hearing. Great question. Yes, Judge Tim.
Okay, HHS has a network of temporary foster,
Emergency foster care placement.
emergency foster care placements, and I'm trying to think what they call not detention, but holding.
Staff secure and secure. They have staff secure, shelter care.
Yeah, shelter, that's it.
Yes.
Okay, so are we coordinating with HHS
Yes.
to get those from their bucket to our bucket?
Yes, we utilize right now all of the shelter care services that DHHS utilizes in our in the state. We'll be able to utilize all of them. We will. We're working towards emergency foster care. There's a little bit of a hitch that there must be a screening done on the juvenile and what have you that DHHS has to approve an emergency foster care placement because they're not in our custody. When they do an immediate removal, they're in their custody so they can place. When we do a detention authorization, they're not technically a ward of us, so we have to go through. We're working with them to get that done in a timely manner so we can access emergency foster care because sometimes it's the home. We don't want to put this kid back in that home because things are chaotic. When we get calls at juvenile intake, it's a crisis. There's some crisis going on, and so it may not be best to put that kid in that home. It may need emergency foster care, come back in to court and get a plan solidified within that 24 hours. And so we will have access. What I've told people is whatever OJS provided in your jurisdiction, we have access to everything that they've had. There's nothing that they've done magically that we can't access or we can't work with providers to create.
Yeah. You know, one of the big problems is that for whatever reason, sometimes good, sometimes just because they're angry, the parents don't want to take
Yep.
the kid back. Now, I understand that, you know, we're gonna work with the parents, but it would seem to me we're gonna have a lot more success if we say to the parents, we're gonna do this for you first, and then get the kid back, rather than say, take the kid back and then we're gonna
Right.
give you all this stuff. And
Right.
if the kid has to stay in emergency foster for a few days, that's a small price to pay.
Right, to let the situation cool down, get services put in so they can implement back with the services. You're exactly right. So that's what we're working towards. The other piece that we're working with is dispute resolution, or working with Debbie Browniard with the, can we put something in place that night? A family sometimes will feel much more comfortable if you say, tomorrow morning at 8 a.m., there's going to be somebody at your door, and they're going to be here to help you. Utilizing that sort of, there's going to be somebody here that can help you with this crisis situation. We can make it through the night. Somebody's going to be here. We will work through that issue. Or, like you said, bring Johnny out in emergency foster care because home's volatile right now and work towards that reintegration in a short period of time. So those are the things that we're looking at. All of those things outside the box, great things to think about at intake.
A couple of things that might help that is like with JDAI, is having that pre-detention staffing to make recommendations, kind of like a mini family team meeting.
Yes.
The issue's going to be timing and how much time to do that. Similar things happen across the youth practice
Yes.
model to kind of prevent further penetration, but that's needs to be built up.
Right. In training with our staff, what we tell them is going out at 4 a.m. on Friday night, doing that detention intake isn't the end of your job when you say yes or no, they're going to go somewhere. That's actually the start because now you have to do the job. And we all know we've been in court that a lot of the times the parents say, I don't want them home, we can't handle it. We put in detention, and then we come back that next morning and they're asking the court, please let Johnny come back home. We understand that because it's a volatile crisis situation at that time. So we tell our staff, when you authorize placement or put somebody somewhere, that's where your job starts, because when you come back in 24 hours, you have to have a plan. You have to present to the court. I've worked with the family, maybe grandma's an option, maybe uncle's an option. Here are some other options, and throw things out there. You don't come back in and say, oh, keep them detained. That's not acceptable. So we have to come up with, that's our time to work to get a plan put in place. Great questions. So juvenile intake, big focus on what we're doing. We want to create more alternatives everywhere. Do we have them today? No. Starting next week on Tuesday, we're not going to have, boom, here's all of our detention options. No. We're building, we're creating, we're building with partners, we're working as teams in these communities to create what these needs are. Okay, I'm going to move on to pre-adjudication investigations, portion of what we're talking about here. Pre-adjudication. So we talk about voluntary services. What does this mean and how is this going to work? What does this look like statewide? There's two types of pre-adjudication supervision. One that we just talked about at juvenile intake. We have our detention hearing and the court can place a conditional release or bond contract or whatever your jurisdiction calls that for that juvenile. And here are the things you need to do in order to stay out of the placement, right? So we know that's really not voluntary because that's just like an adult court bond. You got to follow these things in order to stay out. So there's one type of pre-adjudication supervision that can take place through probation. The next is voluntary. Okay, we talk about voluntary services. How does voluntary services work? We have those juveniles that may come in front of the court, first appearance, and maybe a substance abuse issue, maybe family volatile issues, what have you, and the family saying, I need help. How often does that happen at the first court appearance? Family says, I need something. Can you help me out? So on a voluntary basis, similar to what was able to be done earlier with maybe a 3B adjudication or a 3B filing and front-loading those services, can be done now on law violations and status offenses, where if the family comes in and wants voluntary services, the court can say if it's a voluntary service, we'll order probation to engage. It could be supervision, it could just be service delivery, or it could be both, depending on what the need is of that juvenile. So we put this in place. The question came up yesterday that what juvenile is going to come into the court and say, hey, can you start supervising me more, or can you put me in this service over here? We don't see that, right? We don't see that. So the question was posed to the committee yesterday, is it voluntary when the family comes in and is requesting this? And I think Judge Rowland had a great response to this yesterday and says, if a family's in front of me and says, we need help and we need things here, I'm going to look at Johnny and say, you want to go back home? Are you going to do these things? And you'll get a yes, I will. That would move into that voluntary realm. That family's asking for these things. Now, there's a difference if the family doesn't follow through here compared to if those that detention order doesn't follow through. Well, that's very specific. The court says if you don't follow through, here's what's going to happen. There's something that's going to happen because it's a conditional release. Voluntary services get put in place. We go for a while. Maybe the family says, I don't need IFP anymore. I don't want this person in my home, what have you. They asked us for these services. We'll report back to all parties. Here's what took place. Court put these services in place. The family's now saying they don't want to cooperate with these services or want to back out of these services, or it's not the right service or not what they thought, whatever it may be. We'll notify the court and all parties that they no longer are requesting voluntary services. Then we come in for adjudication and go down the court process. Okay? So a little bit of a difference when it's voluntary. Any questions on voluntary service? Yes, Judge.
Corey, where does the county attorney's diversion programs fit in this scheme?
Great question. So if your county has diversion, obviously that decision may be made before it even comes to the court. So I'm gonna maybe go on a little bunny trail here. So one of the benefits to pre-adjudication services are, if we can address those issues with that juvenile up front, do we really need full court involvement or probation supervision later on? A couple benefits to this. Juvenile comes in, maybe it's an MIP. I'm not minimizing MIP in any way. Maybe it's an MIP, juvenile gets MIP, filed in court, parent comes in and says, yeah, I think Johnny's come home drunk a couple times, we need a substance abuse eval. Get a substance abuse eval, they follow through with outpatient treatment. County attorney says, we've addressed the issue. They've followed through with aftercare. We feel the family's engaged. They've done what they need to. Judge, I'm going to withdraw this. I don't even need to go through with an adjudication on this charge because they've followed through everything. Right? That's the premise of the juvenile court. Divert when possible. The other is, maybe they do get adjudicated, and we've done this as well. At disposition, if they've completed everything and done anything, we don't need to go to that deep end and place on probation. The court can say, you've completed everything, you're done, you're disposed of. The court is complete, you've completed everything that we've required throughout this time frame. So there is a benefit. We really looked at this as we were working with the legislatures as, it's one of those things, if we can address issues up front and deal with them as we're right then and there, I think it's going to help us on the back end. We feel we can address those things in a lot timelier fashion than wait for disposition, because we know in some courts, I'm not picking on Douglas County, but Douglas County sometimes it's 6 months before we get from first appearance to disposition. And if it's already been asked up front on a law violation, here's some issues and I want some help, and we say can't do it till disposition, can't do it to disposition, we've now increased that risk of that juvenile because we've known there's been an issue for potentially 6 months. So here we can address those issues, and I think we're going to have a lot better outcomes and potentially see some of those cases be let go and not go through the full court process. Any further questions? Did that answer your question, Judge? Okay. Investigations. Once court's adjudicated, in past they've ordered either if the family can afford an eval, had insurance, the family would go and get that on their own accord, or they would ask for a OJS, Comprehensive Child and Adolescence Assessment, CCAA 5-part eval, what have you. What we're saying now is the court can order a single focused evaluation. And we've provided the judiciary with a sheet that talks about here are the single focused evaluations, your first tier evaluations, your PTA, your mental status exam, your substance abuse evaluation, your juvenile risk assessment for juveniles who sexually harm. Those are your first tier type of evaluations. Then there's the second tier, your psychiatric and your psychological, which are much more in depth. And so as we go through this process, the court adjudicates, orders probation to get engaged because they want an evaluation. They can either identify at that adjudication hearing, I want a substance abuse eval because it's a substance abuse violation, and parent says, yep, they're coming home high all the time. We need a substance abuse evaluation. 21 days, we'll have that back to the court. If the court is unsure, like a judge asked yesterday, I'm not quite sure, you can order a predispositional investigation. We then can do our upfront screening and assessments that will show a flag of where the issue arises, and we can move forward with that type of evaluation. In Judicial District 11 this past year in the pilot program, we worked with the judiciary out there. They've put in their court order that this juvenile is to undergo a predispositional investigation with probation, and any subsequent evaluation that is needed based on their screening instruments. And so then we would package that investigation and that evaluation and bring that back to the court. Okay? So there's a couple different ways. Now, in statute it says, at adjudication, if an evaluation is ordered, probation has 21 days in order to get that back to the judiciary. We will do that when that court does that. We've created a network and we're building that network as we speak. One of the things that we've talked about is if you order that predisposition investigation and any subsequent evaluation, we're not sure if that kid needs an evaluation or does not need an evaluation. And that takes us time to figure that out. So those would not fit into that 21-day because we have to get the family in, do the investigation, do the risk screening assessments. That's about a 2-week time frame in order to determine. But we will work our hardest to get those to the court in that 30 to 45-day time frame so that we're still not setting out 2 months, 3 months, or what have you. 21-day is specific eval ordered at the adjudication date. Are we good on that?
Corey, I'm sorry.
Yes, Judge.
Would you repeat that again? PDIs are going to take how long?
If you order a PDI and a substance abuse eval from the bench, we'll have that to you in 21 days.
Okay.
If you say order an I'm not quite sure, then we're saying anywhere from whatever your normal time frame is, 30, 45. Some courts it's 30 days, some's 45, some, whatever that time frame is for that PDI, and we would then, during that process, get that evaluation started. We'd notify the court, here is what was flagged as substance abuse during our screening. We're going to refer the juvenile to the substance abuse evaluation, and then we'll package that with our investigation and bring it back to the court. So it's whatever time frame you've had kind of in your everywhere's a little bit different depending on the flow and the number of investigations.
Our length of time in terms of getting PDIs back has gotten greater over the past year.
Right.
So, we're up to 8 weeks before we're getting back.
So 2 months.
And so are you saying that time frame will be condensed under this new process?
Under this new process, if you order a specific evaluation at the adjudication hearing and a predispositional report, that will come together because our focus is what good's an evaluation without all that other background information.
Correct.
So we are working towards building that together to go to the court in that 21-day time frame. If you say, I'm not quite sure what evaluation's needed because I'm not sure what's kind of going on, I want probation to engage in a predispositional investigation to start that process of the assessments and then get that background and history of the family and the school. If something triggers at a substance abuse or mental health evaluation are needed, then they refer out for that evaluation and will bring that to the court in the same time frame you've had for your PDIs.
So those PDIs, because I'm still trying to narrow this down
Right.
a little bit, those PDIs will generally take how long? If I don't have a specific issue, a mental health or a drug and alcohol issue that I want identified, how long is it going to take us to get our PDIs back?
The same time frame that you've worked with your local probation district for that time frame of that. Yep.
So the 8 weeks is what?
If that's what's happening in Sarpy, our hope is by
I know one of the things you've done is hire,
Right.
or in the process of hiring PDI writers, that's all that they're going to be doing, and they won't be doing any supervision. So you don't necessarily believe that those timeframes are going to come down in terms of scheduling.
I hope that was the whole intent and the goal of why we hired specific PDI writers is one, so we can guarantee when we know we have a kid that has heightened substance abuse, mental health, whatever it is, issues, and need that background, we can get those in 21 days because that's crunching that down. And then also to decrease that 8 weeks to maybe 7 weeks to 6 weeks, okay? What I'm first going to guarantee is this. I'm going to guarantee if you order a PDI and a specific eval, we'll get that to you in 21 days. That's what I can guarantee. We will work to decrease the other. I had a question here quick, Judge. Yes?
You may already know the answer, or you may have already covered this. What's the funding stream for these evaluations? Is it coming from Medicaid? Is it coming from you? Is it coming from someplace else?
All of the above. Where is the money coming for these evaluations? These evaluations are coming from all of those sources. If the family is Medicaid eligible in and of themselves, we would tap Medicaid for that evaluation. If the family has insurance, we'll work with the family to provide their insurance. If we have in some jurisdictions where the region actually provides substance abuse evaluations, we'll use that regional funding stream to pay for that substance abuse evaluation. If none of that is available, we then would pay for out of the money that's been given through the legislature appropriated probation for that evaluation. We will never leave a provider hanging that will not get paid. They will get paid. Write that down. Judge Tim.
Well, I think I answered my question, but if I think I know what the problem is, then I can have an assessment and therefore a disposition within the 21 days plus a couple extra or whatever. If I'm trying to think of, would there be a situation where I want to get the assessment and then have to continue disposition? I'm trying to figure out whether I need to schedule, whether it's a good idea to schedule the disposition at the end of that 21-day period. Or wait to see what
If you know specifically, I want a substance abuse eval because there's a substance abuse violation and the family's come in and said, this is an area where we know that Johnny's struggling, you can order a substance abuse evaluation and you can set that hearing 21 days out because we're mandated by statute to have that to the court. We're working with our providers. They have 14 days in order to provide that evaluation back to the court. A lot of people are saying 14 days, there's no way. Well, currently they have 10 days under the CCAA process. So 4 more days when we were working with providers, they're like, sure, that's perfect. We'll take 4 more days. So 14 days comes to administration. We get it to the court on that 17th, 18th day, so they have those 3 days to review prior to disposition. If you have that issue, Judge Tim, where you say, I'm not quite sure, I need a PDI in order to determine what evaluation, set that out as your normal time frame of what your jurisdiction has done for investigations. And then we'll package, if there is a need for that evaluation, we'll refer out and get that done, work with our providers to get that done in a timely manner, or some of those may not need an evaluation because it doesn't trigger based off of our assessments, and we'll just provide the PDI for that jurisdiction. You can't ask questions.
Vicky from the so, you know, the provider can get in that 20 days. Can probation provide transportation to the child to get to the
Yes.
evaluation?
Yes, we provide transportation. We work with providers in some of the areas of the state that they're going to go to the homes or come to the probation office. We're utilizing, we're working with Boys Town right now for those areas that do not have psychiatric or psychological at their fingertips, such as Judge Rowland has to wait for a gentleman to come in from Denver who comes in once every 2 months to do psychiatric evals. Not conducive. We're working with Boys Town to do telehealth services and do psychiatric and psychological testing via telehealth. So the juvenile would come to the probation office with the family, we would work with them, and Boys Town set up time, and they're going to do that psychiatric eval via telehealth. Okay? All right, moving on. Next part is case management. Really, I would like just to record Judge Teskey again and set him here and say, here's all the things you need to do during case management. During that investigation, you need to figure out what the issues are, and you need to then target those issues. And that's what we're going to talk about here. One of the pieces that we're doing, and you kind of alluded to it, Judge, is specialization. So we're going to have officers that are going to specially do investigations in our jurisdictions. So we can guarantee we're going to get those courts, those predispositional investigations. We have officers that are going to specialize in case management, high-risk officers with low caseloads and low-risk officers with a little bit higher caseloads. Okay, so we're really specializing and tailoring those supervision to that juvenile's risk. The higher the risk, the increased what we call dosage, which is the increased amount of supervision we're going to be engaged with that juvenile. The lower the risk, the less the dosage. Not as much, referring out to community supports. They already have some pro-social activities, continuing with those activities. Okay? Providing those services, so if services start pre-adjudication, come through disposition, those services continue if the court feels that that's needed. Okay? Judicial oversight, court's going to be notified. One of the things that, the questions that I've received a lot statewide is, how are you going to remove a kid? How are you going to place a kid? We work with the court. We can only do what the court offers. We can't move kids from placement to placement without working with the court and getting approval of the court. So that's why it's very important in the highly engagement of that judge and that probation officer. Okay? We have a juvenile that's blowing out of a placement. We can remove, come back in 24 hours in front of that court, but that court will be notified as soon as that kid's having issues in that placement. Okay? We notify the court. We're probation. We're under the judicial part of the branch of government, and that's the beauty of why we feel this is going to work with that oversight. Case management is heightened. We have reentry officers that are going to now take place of the old parole officers. That transition is so important, that engagement with the family, putting family supports in place so that family feels supported when that juvenile comes back home. Any questions on case management? Yes?
I'm not seeing the piece for reentry that really addresses the families.
I'll get there.
And how that can be engaged. And as our LADAC and as, seeing the process.
Yep.
If there isn't family engagement, we would be sending a kid back to the same environment and expecting different results.
Right.
As far as truancy, having, like, for an example, like a 9-year-old on probation.
God help us if we keep getting 9-year-olds on probation.
Exactly. Where's the accountability piece?
Yep.
For the parents?
This is a system culture change. Okay? This is a system culture change. 3B petition, which is your uncontrollable, your truancy, which in our system has been a catch-all. Now we're really going to have to focus. Is this a true family dynamic issue where there's potential neglect or abuse? That has to be a 3A petition. If there's any issues where there may not be family permanency, where that issue of there is no legal guardian or somebody that is there for that child, that has to be a 3A petition. Probation is not the guardian of these juveniles. We're an arm of the court puts the court order in effect, and we then supervise that court order. We can't sign a juvenile into school. We can't sign a juvenile into treatment. So with this is why we have to heighten our family engagement. We have to work with that family because they have to be a partner in this process. So the training, we've done specific training. The past month, that's all we've been doing in probation is training. And the next month, that's really what we're going to be doing as well. Part of that piece is we've brought the Family Navigator Network in and said, train us. We need that enhanced family engagement. And this isn't a one-time thing. We're going to continue to build on this because we know we have to have that family present in order to make this work. If that family is disengaged and that family doesn't want that juvenile home, then we've already set that case up for failure. So we look at in-home services, building our wraparound services and in-home family support services, because even though if you move Johnny out of the home, you have to address those family dynamic issues. One of the things that we've faulted in probation is if there was issues in the home, we went to a group home. Very rarely did we put in-home services in place across the state. Okay? Very rarely did we say, hey, do we have intensive family preservation? Do we have family support? Do we have, in some areas of the state, MST, multisystemic therapy? Nope. Things weren't going well at home, we went to a group home. That was what probation did. And then most places in the state, that would go to the Office of Juvenile Services, because now they'd become their guardian and say, we'll take care of it. We're saying now is, we want family services in place. That's why when we're out in our provider conversations, we're working with providers to say, we need you to step up. We can't have you do outpatient in the clinic all the time. I need you in the home. Because I know, as Judge Tessie talked about, those are the services that evidence shows works. And so challenging our provider network to say, we need you. We want you in the home, and we need those wrap services in place. So that's what we're talking about, family engagement. That probation officers engaging that family support's in there, and our providers are. So family team meetings are a part of what we do. Monthly family team meetings in case management and in reentry. And that consists of the family has to be there. And the juvenile has to be there. Otherwise, that's not a family team meeting. If the probation officer, the provider, and maybe the guardian ad litem are sitting around talking, that's not a family team meeting. That's a conversation. And so having our staff step up and say, that's the expectation. Already? Okay.
You know, as it is right now, get sanctioned, you know, at graduated sanctions,
Mm-hmm.
so on and so forth. Where does the accountability piece for the parent as far as probation or, you know, this plan, where does that?
So juvenile has a technical violation.
Correct.
Family reports they came home late. That's a simple technical violation. They had curfew at 10, they didn't come home until 2 a.m. More than likely probably under the influence or something like that, right? We call a family team meeting that week. We sit down with the family and say, what have you done as a family? What were the sanctions, the internal? Because if I'm a parent of 3, my kid does something wrong, there's going to be consequences when they come home, right? As a family, as a parent, I'm going to step in and say, Peyton, you came home late. Here's what's going to happen. You're going to do this, right? So, family, empowering that family to say, what did you do internally? And then support that as a team to say, what else do we need to put in place? Do we need an electronic monitor? Do we need to increase the tracker services to do curfew checks? What other informal or formal supports can we put in place to help that family? Because our families need help. That's why they're here. And so what do we need to put in place to assist them, support them, and then also role model and mentor what it is to be a parent and educate them as well? Okay? Yes?
Prior to the last question, you mentioned the role of the guardian ad litem. Under what circumstances do you envision that a guardian ad litem would be appointed, because they're not necessarily routinely appointed in many cases?
Right. So when would a guardian ad litem be appointed in a delinquency or status, right? A lot of the times there's a tag or a crossover with an abuse neglect, so they may be engaged. But what we're starting to see is the role of the guardian ad litem be enhanced to possibly be engaged with some delinquency cases. As I've been in some national trainings, there's 2 pieces that we're missing in Nebraska. One is a lot of states do have guardian ad litems appointed to delinquency cases, and they have CASAs appointed to delinquency cases. Those are supports that can be there for that juvenile and that family, and I'd like to see our system move in that way. Because a guardian ad litem could be a huge asset to that case. Because I know they are on the abuse neglect side. They can be to that juvenile as well. Another support for that juvenile so their voice is heard. Same with a CASA. Those things can take place. So nationally that's been done where they have been, but a lot of it is in the crossover. One of the things that we're working on, and we're going to expand crossover youth practice model, as Judge Johnson talked about, it's in Douglas County, and we're looking at another 3-county expansion this next year, is what does that look like? How does a guardian ad litem play a role in the crossover? Because we know systematically, anywhere from, you hear low end 40%, high end 60%, those juveniles have had prior or are currently in the abuse neglect system and cross over to the status or delinquency side. What can be done? And so I think we can enhance the role of the guardian ad litem in a lot of areas. I don't know if that directly answers your question, but
Because now, if you have a non-functioning parent, oftentimes that's when you see the guardian ad litem appointed. I mean, the role is different. Instead of the dual role, you have the sole role because the child would have their own defense counsel, so you wouldn't do the lawyer piece that you
Right.
would under the 3A. But I was just wondering, as it relates to, because, boy, there's gonna be a whole lot more demand for GALs, if that happens.
Yes.
And hopefully, maybe you guys could give some grants to CASA so they can have a few more classes.
Supreme Court has one now, and that's definitely something we're looking towards as expansion. Maybe we do a delinquency-only CASA program, you know, those types of things. So thinking outside the box for those supports.
Something would be helpful, because right now, I know I've got cases in Douglas County where I've had an order for a CASA, it's been over 6-8 months before they have an appropriately,
Yep.
a trained and then one that's appropriate for the particular case. So having a CASA-only program for that track could be really
Yes.
fascinating.
Yes. Judge Tim.
I think we're kind of, you know, traditionally, the guardian ad litem has always been an attorney, but a guardian ad litem doesn't have to be an attorney and legal. And it might be helpful to have a grandparent be a guardian ad litem, and that way the grandparent has some status within the system.
I think by statute, GALs in Nebraska have to be attorneys.
We can change statute.
So,
Where'd Senator go? He was here. Write it down.
I think there's more room in maybe some non-juvenile cases, but I thought that code got changed primarily by the bar, because there used to be the exception in certain circumstances, it could be a lay GAL. I think that got changed, what, 15 years ago or
Yeah.
so? Because some CASAs were GALs.
We did that all the time. North Carolina was.
At one point, the guardian ad litem statute said something like, if it was a GAL who was, and then they define what they have to do. And I know I worked with some cases, now that's in probate court where it's they call it a visitor. Don't even call it a GAL, because by definition, a GAL has to be a relationship. So they have another
Yeah,
provision, but
yeah.
I haven't seen that used in a long time, so I don't know if the statute.
Yep.
Just related to
Yeah, these are great discussions of thinking outside the box of what other informal supports or formal supports can we put in to assist these cases. Because as we know, one person, I don't care how good of a probation officer is, and we got great probation officers across the state, it takes more than just a probation officer sometime in these cases. I'm going to move on. I got 1 minute. I'll probably go long. Reentry, because this happens to be one of the big discussion pieces. What does reentry look like? We're still formulating decisions or looking at statute and trying to decipher how this looks a little bit, but here are the things that we do know. There is a 60-day notice that will come out to the court. July 1, the new law went into effect that any juvenile going to YRTC, Kearney, or Geneva must be on that intensive supervised probation order and committed to the department. They're committed so that they can take care of the costs and what have you while they're at YRTC, but there's still judicial oversight, so when that juvenile comes back, there will be that notice to the court. So a 60-day notice will come out to the court. That's when you know this juvenile is going to transition within 60 days. So that kicks in as well. We're using, when we talk about reentry, I'll talk about Kearney and Geneva first, and then I'll talk about on-home. But the mantra with probation is exit upon entry. The day they step into an out-of-home placement, we're already starting to talk about what do we need to do to get this juvenile back home, what needs to be put into place, what goals do they need to work on, all of that stuff. But here where the YRTC, the statute specific, 60 days kicks in that individual reentry plan. What does that plan consist of? That plan consists of a family team meeting comes together, which is happening once a month at the facilities already, and start talking about what needs to take place for Johnny to come home. Do they need outpatient treatment? What needs to happen with the school? Because the school needs to be notified ahead of time so they're not showing up that first day and the school's going, what are you doing here? Right? All of those things need to be put in place prior to that kid leaving that out-of-home placement. So from the court's perspective, 60-day notice will come. We do our assessment. We do that individual reentry plan. That juvenile will come back. There is a hearing that will take place. Can I just leave it at that, Judge Johnson? There is a hearing that will take place. They're still deciphering whether that's at that 60 days, prior to that 60 days, or after that 60 days. But statute does say that there will be judicial review or hearing. That reentry plan will come back. One of the pieces why I was insistent with Senator Ashford and Chris that probation had to be engaged in this reentry plan was this helps deliver that to the court. So we're at day 30, we're notifying the court, here is the plan. So the probation officer can go to the court and all parties and say, here's the plan, here's what we're looking at reentry, and the court can say, that's right on track with what we're thinking before we sent, we know we needed these things when they came back, or no, we really need a step down, this kid may need something different. We then can modify that plan. That's the beauty of why we wanted to be engaged, so we can keep that court abreast of where that reentry plan is, so it's not a mystery at day 60, the kid's getting discharged and what's going to happen with this kid. Where it's that fluid document, that's notification, so everybody knows what's going to happen with this kid when they're coming back home. And those supports will be put in place for that juvenile. And then the court has a hearing to determine what's the length of their reentry. What is needed, how long is this going to take place, and what's happening. We're really, from my standpoint, I believe that hearing is so crucial for a couple things. One is to celebrate that juvenile made it through YRTC Kearney, our highest level of care, or Geneva. Celebrate that you did a great job, you've made it through, you've made some positive change in order to transition back home. Here's the things that you need to do in order to be us all out of your hair. Do X, Y, and Z, and we're done. Keep that going, that momentum. That judicial support is crucial with that juvenile and that family. It also shows that judge is invested and engaged in the success of that child. Yes?
Corey, the YRTCs, what's going on regarding transitioning the YRTCs to being more treatment focused as opposed to, particularly at Kearney, the positive peer culture?
Right. Here's what I'll speak to. I'm not going to speak to what they're currently doing at YRTC, as I'm not, with DHHS. But what I can tell you is the Children's Commission, which was a commission that was created in order to look at some of these issues. There is a subcommittee under the Children's Commission called the Office of Juvenile Services Committee, which some of you in this room are engaged in that. And Ellen Brokowski is co-chair with Marty Klein, from Deputy County Attorney from Hall County, of that OJS subcommittee. The role of that committee is to make, in very short order, make recommendations to the Children's Commission, which ultimately will go to the legislature on what should Nebraska's highest level of care look like. It's not what should Kearney and Geneva look like, it's what do we want as our highest level of care. We've already determined that it's rehabilitative. It needs to be way more rehabilitative than our current system. Now, what does it look like facility? What does it look like? We're not there yet. But I will tell you that there's going to be some strong recommendations to the legislature that this is what we feel as a system our highest level of care needs to look like. And we're not basing it off of current facility. We're not basing it off of what they currently do. We're not basing it off of what they currently don't do. We're basing it on experts in the room saying this is what it's going to take to build the highest level of care for the kids in the system.
Because frankly, the transition planning is predicated upon what has happened at
Currently, yep.
And if we haven't gotten that figured out, then we're just going to be doing a lot of the treatment, taking care of a lot of the treatment needs once the child's released from one of the facilities. So
currently, you're exactly right, Judge, that if a kid has a substance abuse issue and it's identified at Kearney, are they getting the right level of substance abuse treatment at the facility? No. So when that juvenile's coming out on reentry, that's the number one thing we're going to address is what level of substance abuse treatment is that juvenile going to need, and we got to get that juvenile engaged in that. So that's where we're at now. Ultimately, the hope is that that'll change when they go to that highest level. They're getting those treatment modalities taken care of and those treatment issues. So reentry, that's what we look like. Out of home is similar. Out of home care, I'll get you one quick second, Alicia. Out of home care, what we're building in our system too is anytime there's a juvenile in out of home care, a reentry plan takes place as well. We will work with our providers, so if a juvenile's in a group home, there's that 60 days. This juvenile's getting ready to transition in 60 days. We then create that individual reentry plan and move that juvenile back home with the court's approval. So those types of things will take place as well with out of home. It'll be a little more flexible because we're not tied in statute to 60 days that kid is discharged. Because right now, the way the statute reads is at 60 days, at that 60th day, YRTC will discharge. Okay? So there's a little more flexibility. We're not bound by that, but we want to work that. Yes?
What investigation is going to be done on placements of children in what I would call
Right. So if there's a non-custodial placement, couple different things. If it's at juvenile intake, we'll do a background check. We'll talk with the family. We'll do a brief interview with that aunt, uncle, let them know, what have you. They're back in front of court within 24 hours. We can do a more formal assessment. At any point in time, if that juvenile is going to be placed with a relative or with a family friend, that whatever it may be, the court wants to do that, we have the option to do the family assessments that are currently done. We've worked with all of our foster care providers, our agency-based foster care providers, to provide home-based studies. There's two types of studies that we're talking about. One is to make the court feel sufficed, because we know we won't be able to license this family. So it's a condensed home study, because they're not going to be all of those regulations that they have to get licensed. They're not going to be able to get licensed anyways, so those are done. But it's still, is this a clean home? Is this a safe home? Here's the background checks on the individuals in the home. Here's who's going to be in the home. All of that core stuff can be provided for the court. So we've worked with our agency-based providers in that framework for those types of cases. Yes, Judge.
Corey, that's your affirmative planning. You know, if it looks like it's bad family, technically, you know, adoption's an option, but you hold a 3-8K bonus. I think more likely you could have guardianship, relative placement, or another plan living arrangement. And that's why we've got to have affirmative planning. And if we haven't been doing that, we should have done it with 3Bs and OJS prior, because ASCO applies to those out of home placed kids.
Great questions. I'm over time. I'm going to wrap up. I am here till probably noon or shortly after, then I need to get back to Lincoln. So if there's any questions, feel free to come up and ask. I'll also roam around during your meetings. If there's any questions that come up as well, you also can contact me at any point in time, and we'll assist you in any way we can. So appreciate all the support. And also, as we work towards building this system, it's not a one-year turnaround. This is really building the foundation, and this is 2, 3, 4 years out of where we're going to start seeing those successful outcomes that we all know and want. So thank you.